I'm Nick. What we're going to do today is we're going to go through contracts and how child support does not abide by the maxims. The maxims of equity, the maxims of contracts, the maxims of law. You know, they don't do none of that. Like, at all. So, here, let's get into it. All right, where do I want to start? Okay, so this is Wikipedia. All right, United States contract law. This resource right here, I was like, oh my goodness, this is a first good Kickstarter for everyone. So this is kind of long. I'm not even gonna sugarcoat it. But oh my goodness, the things you will learn in here, infinitely more potential in just this than many of the entertainment things that you may be watching. Just telling you straight up. All right. Contract law regulates the obligations established by agreement, whether expressed or implied, between private parties in the United States. The law of contracts varies from state to state. Okay, these mean two different things right here. That's why one is highlighted and one is not. There was a nationwide federal contract law in certain areas, such as contracts entered into pursuant to federal reclamation law. The law governing transactions involving the sales of goods has become highly standardized nationwide through the widespread adoption of the Uniform Commercial Code. There remains significant diversity in the interpretation of other kinds of contracts, depending on the extent to which a given state has codified its common law of contracts or adopted portions of the reinstatement second of contracts. So is a legal Okay. Formation. All right. So let's get into agreement. Mutual consent. This is what agreement is in contract law. Also known as ratification. Ratification means to make official. And meeting of the minds is typically established through the process of offer and acceptance. However, contracts can also be implied in fact, as discussed below. At common law, the terms of the purported acceptance must be the mere image rule, which means what you're paying needs to mirror what you're buying. Of terms, the offer. Any variation thereof constitutes a counteroffer. An offer is a display of willingness by the promisor. These are actual legal terms, okay? To be legally bound by terms they specify, made in a way that would lead a responsible person in the promisee's position to understand that an acceptance is being sought and, if made, results in an enforceable contract. Ordinarily, an offeror is permitted to revoke their offer at any time prior to a valid acceptance. So what that means is, if they make a second offer and you accept the first one, they can revoke the second offer, or they can revoke the first one. Vice versa. You know what I'm saying? So now it's not under the terms of that first offer, it's under the terms of the second offer. Okay, this is pretty much self-explanatory. I know, trust me, I know. But there are words that they use in these contracts that you don't know. And if you do, not everybody knows. Okay, like promisor, promisee, offerer, offeree, obligor, obligee, like all of these, they mean completely different things in different circumstances with pertaining to you or the other party. And it's like, oh my gosh, like well you guys have to make this as complicated as possible, don't you? All right, so let's move on. Uniform Commercial Code. All right, dispenses the mirror image rule in section 2-207. All right, and UCC section 2-207(1) provides that a definite and reasonable expression of acceptance operates as an acceptance. All right, that can be oral, that can be written, that can, that these things matter. Even though it varies the terms of the original offer, such an expression is typically interpreted as an acceptance when it purports to accept and agree on the following terms of the original offer: subject matter, quantity, and price. However, such an expression is not interpreted as an acceptance if it is expressly conditional on the original offerer's assent to the verified terms discussed below. This language is known as the proviso. When the proviso is not used, the terms of the contract are determined by subsection 2. When the proviso is used, but there is no assent by the original offerer to the offeree's varied terms, yet the parties go ahead and perform. What does perform mean? It means to pay. All right, that's what payment means. Performance on an obligation or a contract. All right, so what they do, okay, so this is what they do. I mail you something, right? I expect you to mail me back something. You see, I expect a response. I expect you to perform. That is payment. Yeah, that's where we're at. That's where we're at. Literally, that's all payment means. To make a payment means to perform. If you go over and take a couple of courses, I'm gonna help you out with all that. All right, but here in child support, if they ask you for species or money, you got them. You got them, and you don't even understand how good you got them. All right, because they're asking you to pay. But if they ask you for money or species, which is gold and silver coins per the Constitution, then you can be like, look, I can't pay you. I can't pay you with that because you guys took away my ability to. So 18 USC 8, it's clear states, United States assumes all debt of all persons, public or private. So because of the Banking Act of 1933 and the Social Security Act of 1935, you guys left me no reasonable way to pay. You got him by the ball. All right. So that's Uniform Commercial Code. It is amazing. If you actually go through it, there is so much in there that you can link up with, consumer rights, that you can coordinate with federal law, federal regulation, federal revised statutes. Oh my gosh, it's ridiculous. And since every public entity is within the U.S., so there's U.S. contracts, right? Then you can use it everywhere. Utilities, it doesn't matter, public or private debts. I'm telling you, go look it up. And here, you know what? I'll look it up for you. Check this out. The term obligation or other securities of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, or drafts of money drawn by. Did I reverse these? I think I reversed these. Give me a second. No. What? Make no sense. I may have forgotten. Oh my gosh. Did I forget? Certificates of deposit, bills, checks, or drafts for money drawn by or upon authorized officers of the United States, stamps and other representative value of whatever denomination issued under any act of Congress, and canceled United States stamps. Obligations or other security of the United States defined. Oh, is the defined. Okay. I can't believe I forgot it. No, I'm gonna have to hold on a second. That's it. How did I forget this? Oh my gosh, just gonna rack my brain until I figure it out. Organization fund. As used in this title, the term organization means a person other than an individual. Oh my gosh, that is so plain. I'm a title. That's funny. Okay, let's go back. I have to freaking save this. Okay. Maybe. I have to find this later for you. Oh, wait. Okay, good clauses in contract. Okay, Now I gotta find the corresponding. Where is the corresponding one? The code for that. Well, I'm gonna have to find this later. How did I deal with that? Box. No, it's not. Oh, it's in my briefcase. I just put that in there. No. I cannot believe I didn't save this. I'm so upset at myself. Jeez, old Pete. Well, I guess when I find it. Well, definitely. Come back to it. All right. So now we get to consideration and estoppel. All right. So after agreement, that's what agreement is. All right. There has to be, or before agreement, there has to be consideration. All right. Consideration is something of value given by a promisor to a promisee in exchange for something of value given by a promisee to a promisor. Typical examples of things of value are acts, forbearances, and or promises to do so. The latter referring to those things that a party has a legal privilege to do in the first place. So promising to refrain from committing a tort or crime is not a thing of value for purposes of consideration. This is known as a bargain theory of consideration and requires that the promises to exchange the things be reciprocal, whatever that word is, induced. This is especially important for the discussion of past consideration below. All right. Let me go into examples here. This is on Wikipedia. You can check this out yourself. All right. Here's examples in case laws. Oh my gosh. Okay. So, modification of contract does not require consideration if the change is made in good faith and agreed by both parties. All right, consideration is actually a legal term, and it's not at all like, it's way more in depth than what you think. All right, consideration is huge. Formality. Ordinarily, contracts do not have to be in writing to be enforceable. Oral or in writing. Look, these things, it gets crazy, man. That's how they're able to get away with all this stuff. Because if you don't know contracts, you don't know the procedures of contracts, and if you don't know how to enforce your rights when contracts are being held, like, you'll get trapped in a system like I did, okay? Because I didn't know none of this stuff. You know, I was just a young kid thinking that I was, doing right by my kid. And really, I was becoming a slave to, the public treasury and to a corporation that is private, an agency that's private, that's controlling the government through provisions and checks and bribery. It's insane. because they wanted to turn me into cattle for them. And, turn the mother against me and everything. And it was sad, really. It was terrible because, like, I tried to be there. Like, I really did. Like, I gave it my best effort, and it didn't matter. They still villainized me. They still made me out to be something I wasn't. Like, all to further their agenda, because that was a part of their agenda, to exile me, to, do all these things so that they could continue to get wealth off of me. And that's what, plain and simple, that's what child support is. And you need to understand that. This is not a service for the people. This is a service to divide the home, to have federal governments interfere in family affairs so that they can have more control. And it's not fair. And it's not right. It's fraud. And it's coercion. It's under duress. It's all void. But there's a hazing process. And if you don't understand your rights, if you don't understand these procedures, their procedures, that don't even apply to you, but they assume they do. They assume they do. So what are you going to do about it? You're going to put your head down, you're going to learn, and you're going to come back with a vengeance. Because what comes in between you and your kid? Nothing. No one. Ever. So, you got breach of contract, performance-based, damages, examples, specific performance, that's that expressly, qualified, quasi-contract, arbitration. Arbitration is like, this takes place in child support a lot. I mean, a lot. It's almost every single time. Parties are permitted to agree to arbitration disputes arising from their contracts under the Federal Arbitration Act. Okay, so this is outside the court. Now, this normally only happens a few times when establishing child support and when establishing custody. Okay? Now, when doing this, honestly, there was no jury, there's no judge, there's just a witness. That's about it. And then that witness reports to the judge. Okay? And to be quite honest, when you're dealing with someone who's all gassed up by the courts telling them how much, money and all this stuff, and if they do this, if they do this, if they do this, they'll get this, they'll get this, they'll get this, they'll be able to get a new household, they'll be able to use the father's income, be able to use the father's, like everything. Like, it's just like, are you serious? Like, so now I'm not allowed to have a life because you guys chose to interfere in family affairs, knowing the Constitution, knowing the law, and still yet you do it anyways, because you would rather have money than people who respect their government for doing their job. I'd choose the honor all day. And that's the difference between me and you. Me and the government are not the same. All right, so unjust enrichment, that's what's happening. With child support, it's exactly what's happening. Restitution, construction, express terms, implied terms, unconscionable terms, canceling the contract by mistake, misrepresentation, illegality. Yeah, such a good source. So United States contract law, law of the United States, show. Yeah, so here's all of these. You can go and check out every single one of these. It is so cool. You can use these in your court cases. Like, oh my goodness. Yeah. And look down here. You can look at all of these too. Great resource. All right. So now let's get into the Constitution. All right. The separation of powers. How is child support able to be in the judicial and administrative if it's coming from contract? It's not. It's not allowed. But it does because it has created federal regulations, U.S. codes to pretty much be able to steal from the American people. And it's sad. All right, so let's go back. Boom. Oh my gosh, this is terrible. Okay. There we go. Separation of powers is a doctrine of constitutional law under which the three branches of U.S. government, executive, legislative, and judicial, and their duties are kept legally separate. This is also known as the system of checks and balances because each branch is given certain powers so as to inspect and block other branches who may overstep their duties. But right now, we have judicial and executive in each other's quarters, especially with child support. Why? It should only stay in executive branch. The administrative branch. You know, when you go to court for child support, pretty much if you don't do what they want, they move you out of civil and into judicial. Why? Why? Never have I ever heard of anybody going to jail over a contract besides in child support. Well, that's what we're going to find out. And then we're going to stick it to them. Me and you. Let's go. Alright. The separation of powers doctrine divides government responsibilities into the three branches in order to prevent any one branch from taking over another's duties. The goal of the farmers and their creation of the separation of powers, framers, was to prevent a concentration of power by one branch and thus unequal control over the government. So they didn't want one branch becoming too powerful so it could overthrow the other branches. But that's exactly what's happening in child support. Doesn't make any sense. Like, they don't follow the Constitution at all. And so, hold on. Oh, jeez. So, in, what was it? I think it was the U.S. Code, the U.S. Code video. It said, all child support enforcement agents have to follow all other codes of federal regulations and laws. Well, there's laws completely rebutting. I'll get into it later, but you're gonna love it. You're gonna love it. This is the slow part. This is the slow part. You're gonna have to, trust me. You'll get it. Contracts create legally binding agreements that courts can enforce, requiring clear offers, acceptance, and consideration. 6 main types of contracts include unilateral, bilateral, express, implied, quasi, and promissory estoppel, each suited for different scenarios. Contracts may be written, verbal, or implied based on actions and circumstances, but all must meet core legal requirements. So, what this is saying is, you don't even have to say it. You don't even have to write it. You could look at somebody, read their mind, and have a contract like, hey, yeah, this is enforceable by law. What is, dude? Like, what is enforceable by law? This blows my mind. It's terrible. Not okay. Not okay. You ever locked eyes with a woman like, yeah, it's enforceable by law? Like, what are you talking about, dude? Like, yeah, I'm gonna take you all the way to court, honey. She might take that one of two ways. Like, oh gosh, either he's putting a ring on my finger or he's gonna sue me. Oh, that's funny. That's funny. Alright. Okay, I'm back. I'm sorry. I'm back. I had to cheer myself up. I'm back. I'm not back. It's too funny. Let's go back and look at it again, please. Okay. Oh my gosh, where is it? Where is it? Where is it? Okay. Stop! Stop! That's so funny. Okay. Contracts may be written. Sorry. Contracts may be written, verbal, or implied based on the actions and circumstances, but all must meet core legal requirement based on actions and circumstances. That means fucking anything. Gosh, have you ever locked eyes with somebody like, yeah, I'm gonna hit that, yeah, and they just looking back at you like, yeah, I'm gonna hit that. And it's legally binding. So she didn't let me hit, Your Honor. Stop! It's too good. I would love to see a man get so pissed off at that. Or even a woman, like, going to court, like, Your Honor, he didn't let me hit. That'd be comedy. I would literally pay to see that. Oh, I would pay. Oh, man. My ancestors are tickling my funny bone right now. Fuck, that's so funny. Ooh. Okay, let's keep going. I'm back. No, I'm not back. Give me a minute. Okay, come on, Nick. Okay, understanding and selecting the right contract type ensures better decision making and risk management in personal and professional agreements. They were real professional about it when he said he was gonna fuck me, but did it. Oh my gosh. Oh, that's so funny. This law stuff, it will literally... it's hilarious. This is hilarious. Like, are you serious? This is the parameters on contracts? Are you, Oh my god. Okay, legal contracts shape modern business relationships and personal transactions. And when you grasp the various types of contracts and their implications, you make better decisions and protect your interests, whether you're a business owner, professional, or someone signing an agreement or trying to get laid. Oh my gosh, this is so funny. Oh, I don't know if you guys are having a good time, but I'm having a good time. This is hilarious. I cannot believe that it is this plain. Like, this is scary. But I mean, on a very serious note, like, it has to have this much freedom because we are by nature divine, you know? So this is God-given freedom as free will, you know? So it's like, it has to be like this. They have to follow those parameters, you know, regardless how funny I make it, you know, but it's the truth. They have to. All right, the basic elements and classifications of contracts. For a contract to stand legally valid, it needs to contain fundamental components. All right, a clear offer, acceptance of that offer, something of value exchanged, consideration. This is what child support does not have, okay? Child support, you get nothing out of it. You get nothing, all right? If anything, you lose more. Legal capacity of all parties. All right, so legal capacity, understanding the legal side of it. That's meeting minds and stuff. It doesn't do that either. They make sure that they say they're something when they're not that. Because when contracting with a child support agency, you'll see later on in this course that they are operating as an agent of the child support agency and not in their official capacity as judge, prosecutor, or lawyer. You understand? When dealing with child support, they actually forfeit their office. Because you cannot contract outside of your oath to the Constitution. And when you do that, you forfeit your oath to the Constitution. I have all the oaths of office. And then that'll be later on in a video in this course. I'll show you, and trust me, you'll want to see it. Mutual intent to create binding obligations. There is no mutual. So these last three, child support does not have. All right, because they can't prove mutual intent to create binding obligations to each other. They cannot prove that. They cannot prove the legal capacity of all parties. They cannot prove that. They cannot prove something of value was exchanged of consideration. They cannot prove that. You have to. And once you prove that these three things did not happen and has not happened since the inception of this void, invalid contract that they're going to have to pay you all your money back for and damages, then, you get to walk away. Contract types and the real world applications. All right. Core contract classifications. The choice between unilateral and bilateral. The first key distinction in contracts splits them into unilateral and bilateral agreements. A unilateral contract needs just one party to make a promise. Think of a lost pet poster offering a reward. The owner promises to pay, but no one else has made any promises yet. This is kind of what child support is right here. Most businesses deal using bilateral contracts where both sides make promises. Picture a standard vendor agreement. The supplier commits to delivering products while the buyer commits to payment. These form the foundation of most business relationships. Clear versus implied agreements. Written contracts spell out all the terms clearly. What legal experts call express contracts, business owners prefer these because they leave less room for confusion. A commercial property lease serves as a perfect example, laying out exact rental payments, time periods, and what each party needs to do. All right? You got modern contracting evolution, fixed versus flexible pricing, and then there's a lot of moving parts inside of building a contract. All right. But what we're trying to do is we're trying to cancel out contracts. Feel free to go to the contract killer course. All right. Because one of the best courses I've ever done in my life. All right. So let's move on. No. Where is that? I've been trying to look for that too. All right, so this will give you a good idea of what's going on. All right. So, here's what contracts have evolved into and the legal representation of yourself. 1809, Bank of the United States versus Devonox, or Deviox, whatever that is. In the early days of the Republic, that means common law, when the state and federal courts were still working out their jurisdictions for maritime law. The Bank of the United States, a precursor to the U.S. Treasury, sued a Georgia tax collector named Peter Dixios, whatever his name is, for property he had seized when the bank failed to pay state taxes. Oh, really now? Dixios argued that because corporations weren't people, they couldn't sue in federal court. Chief Justice John Marshall agreed. This meant businesses could only sue or be sued in federal court if all the shareholders and at least one member of the opposing party lived in the same state. According to Bert Newborn, a corporate law professor at New York University, Wall Street banks hated this decision because it restricted suits to state courts where judges were partial to the bank's local clients, typically Midwestern farmers. (1844), Louisville, Cincinnati, and Charleston Railroad versus Letson. It soon became apparent that Marshall's decision and Bank of United States was unworkable because it put corporations outside the reach of federal courts. 35 years later, after hearing the Louisville, Cincinnati, and Charleston Railroad case, the Supreme Court shifted course, ruling that corporations were citizens of the states where they incorporated. Still, it was difficult for corporations to sue or be sued in federal court unless all its shareholders lived in the same state. You see where we're going here? Oh, wait, it gets worse. It gets worse. (1853), Marshall versus Baltimore and Ohio Railroad. The Supreme Court later upheld the notion that corporations were citizens, but only for the purposes of court jurisdiction. They did not have the same constitutional rights as actual people. The court also ruled that for litigation purposes, shareholders would be considered citizens of their company's home state. This made it easier for corporations to sue or be sued in federal court by eliminating jurisdictional conflicts. 1866, County of Santa Clara versus Southern Pacific Railroad. You see, the railroad was more than just the railroad. The railroad was a ploy for the federal U.S. government to establish a de facto government on top of the de jure government. Do you see what's going on here? You remember Abraham Lincoln standing next to the railroad? All right, now watch what happens. Now that corporations were legally citizens, corporate attorneys worked to expand their rights. When California officials levied a special tax on Southern Pacific Railroad, the railroad sued, arguing that singling out the company violated its rights to equal protection under the 14th Amendment. 14th Amendment made everybody slaves, which was intended to protect freed slaves. What it really did was make everybody slaves to the de facto government. In a strange twist, the court reporter, a former railroad man, wrote in a published notes on the case that the 14th Amendment did in fact apply to the company. Even though this notion appeared nowhere in the High Court's actual ruling, 11 years later, the court declared it was well settled that corporations are persons within the provisions of the 14th Amendment, citing Santa Clara. (1898) Smith versus Ames. Building on Santa Clara's decision, the court voided a Nebraska railroad tax. Look at this. It's around the railroad. Every single one of these are around the railroad. And what did they all do? They strengthened corporations while weakening human beings, actual Americans, ruling that it was akin to the government taking a corporation's property without due course or due process, a violation of its 14th Amendment rights. The decision was overturned in 1944, Federal Power Commission versus Hope Natural Gas decision. 1906, Hale versus Hennekel. Having blocked unlawful seizures of corporate property, the court went on to shield companies from other kinds of intrusion. Writing for the majority, Justice Henry Billings Brown found that corporations, like people, are protected from unreasonable searches and seizures under the 14th Amendment, although the 14th Amendment protected against self-incrimination did not apply. Human beings have that right. The protection against self-incrimination, but corporations do not. So that's why you see child support law the way it is. Because if you don't understand law, you're considered a corporation of the U.S. de facto government, which is a piece of paper. It's a business. You're not a citizen of any business. You're a citizen of America. (1931) Russian volunteer fleet versus United States. See, this is when they changed from the Bank of the United States to the United States government. This is when the business started. All right. A Russian shipbuilder, Russian volunteer fleet, sued the U.S. government, not the USA, the U.S. That's de facto, not de jure, claiming that government officials had unlawfully seized property worth more than $4 million. The High Court sided with the company, ruling that even foreign corporations are protected from unlawful government seizures under the Fifth Amendment, which ensures fair treatment by the legal system. There's two constitutions. One constitution's for de jure, the actual land. One constitution's for the corporations. The law of the sea, the law of the land, the law of the sea. The first constitution of your state and the first constitution of America. The second, third, or fourth, whatever, revised of your state is the incorporation. All right. The second constitution of the U.S., that's for the incorporation, the law of the sea. So again, we see how they're trying to turn people into corporations. 1977, United States versus Martin Linen Supply Co. After a criminal trial for two linen companies and their owner was dismissed due to jury deadlock, federal prosecutors appealed the decision. The Supreme Court ruled that the second trial violated the company's rights to be tried only once, expanding on the double jeopardy rule to include both humans and corporations. See what they're doing here? See what they're doing? They're trying to turn you into a corporation so that they can have more jurisdiction over you. That's how child support is getting into the homes of people. That's how the federal government is getting into the homes of people. Because they're assuming you are a corporation under their jurisdiction. 2010, this is recent. Citizens United versus FEC. In the run-up to the 2008 election, the Federal Elections Commission blocked the conservative nonprofit Citizens United from airing a film about Hillary Clinton based on law barring companies from using their funds for electioneering communications. Within 30 days of the primary or 60 days of a general election, the organization sued, arguing that because people's campaign donations are a protected form of speech, see Buckley and Velo versus Velo, and corporations and people enjoy the same legal rights, the government can't limit a corporation's independent political donations. The Supreme Court agreed. The Citizens United ruling may be the most sweeping expansion of corporate personhood to date. 2014, Burwell versus Hobby Lobby. Corporations are legally people with the right to free speech. But do they have religious rights? Apparently they do. In 2012, Hobby Lobby, an Oklahoma-based craft store chain, sued the federal government, arguing that a provision in the Affordable Care Act requiring it to provide contribution coverage for employees violated shareholders' constitutional rights to freedom of religion. The Supreme Court sided with Hobby Lobby and found that corporations can assert the religious rights of their owners, greatly expanding the power of shareholders while creating a world of confusion for corporate attorneys. So, You know where we're at? Now we're at child support. They assume you're a corporation, so they treat you like one. They invade your home, do whatever they want, because they believe that you don't know any better. What are we going to do about that? Look, this has been Contracts. I'm Naganik. I hope you enjoy the course. Keep your head up, and remember, God is with you. Later.